I've seen a little clear plastic thing or change the windshield wipers.
Is that evidence? Oh, yeah.
Guard still on. Aha moment.
Yes, we're ready.
Ready? Okay, this is a call to order of the Appraisal Review Board of Aransas County. It is December the 9th at 1:30. Do we have a quorum?
Yes, sir, Mr. Chairman, we do.
We have a quorum. In that case, we're open to hear and determine property tax code. We're open for hearings under property tax code for 15576.
We are going, our first check-in today was for case 2296, which is under the name of Schweizer. It's
Account number 63967.
Okay, so we'll,
Sure, you can. Just,
he's not here.
yeah, Jim's on Zoom,
And
but he's not representing this case. No, he's just listening.
That's why I'm wondering if we wanted, do you want him to come in?
Yeah, sure.
Okay.
okay, and is this by,
they're here in
They're
person.
they're here in person?
Mhm.
Yeah,
okay.
What Scott's referring to is Attorney Jim Evans is going to zoom in for a case today, and this isn't the case, but Mike said to go ahead and let him in the
Okay.
room for
Yeah.
this.
It's a public meeting, he can listen.
You want to bring him in?
I'm ready.
Okay.
He is in.
Hey, Jim, just to let you know, if you can hear me, this is not the case that you're representing, but you're welcome.
Yeah, Val had mentioned that I think the third case is the one I'll be participating in.
It's very possible the person for the case you're representing is not present.
Yeah. Okay, I will stand by then.
That's great.
Turn around and I'll bring one more chair. This is Tammy Schweizer. Hello.
Tammy.
And this is Daryl Schweizer. This
We'll
is
have,
our ARB. I'm gonna
one
bring
more
one more
chair.
chair.
Sorry, we don't get out much. You're bringing your chair. Here you go. Yes, please.
We all set? All set? Okay, we're opening a hearing on case ID 2021-2296, account 63967. This hearing is being recorded. What's the protest?
Under protest, it's a 2525D.
Okay. We're the Appraisal Review Board that will be hearing your protests today. The board is these five people around the table here. And Mike represents the appraisal district. We do not work for the appraisal district. We are appointed to perform an independent review of your protest. At the end of the hearing, you may complete a survey regarding your experience. Survey may be completed using the survey form and email to pcad.communications@cpa.texas.gov or online at surveymonkey.com/r/survey ARB. Survey is voluntary, but we do appreciate it if you take it. You also have the right to appeal our decision. Appeal information will be provided to you with our determination. At the end of this hearing, you'll get a document in the mail that tells you what the result was. It will also give you instruction and information about how you can appeal further if you don't agree with us. In accordance with Tax Code Section 4145H, all written material that has not been provided must be provided at this time. Do we have all of your evidence?
Yes.
Very good. ARB members who are considering the protest have not communicated with anyone about the protest and are signing an affidavit to that effect. I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of tax code section 4166F.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I, Kathy Hoffman, do solemnly swear that I have not communicated with another individual. What's most of it?
In violation of tax code.
In violation of tax code 41.66.
I, Bill Duck, do solemnly swear I have not communicated with another person in violation of tax code 4166. I, Scott Wagner, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
All testimony from all witnesses must be given under oath.
You'll just read that.
Okay. I do solemnly swear or affirm that the testimony I shall present to the appraisal review board for the Aransas County Appraisal District is true and correct.
And if you'll state your name
Tammy Schweizer.
and Mr. Schweitzer.
I do solemnly swear or affirm that the testimony I shall present to the Appraisal Review Board for the Aransas County Appraisal District is true and correct.
My name is Michael, so I do solemnly swear affirm the testimony shall present to the appraisal report of the Aransas County Appraisal District is true and correct.
I am obligated by the state of Texas to ask if either of you have a Texas appraiser license.
No.
Okay. Now, if you look at, is the blue chart,
It is, that chart right there, Ms. Schweitzer.
This one.
Yes.
there you go. That's the way we'll proceed with the hearing. And you'll see there's two major columns there.
Yes, sir.
And that's because you get to choose whether you speak first or whether Mike speaks first for the district. You get to make that choice.
Okay, I'll go ahead and speak first,
You have 5 minutes,
starting now.
starting now.
Okay,
Let me ask a quick question. I'm sorry.
Yes, sir.
You're going to be talking about pictures and you have provided us with the stick drive and with photographs. And are there photographs that are on this that you did not provide the photographs
I
also?
believe there are a few, but with the photographs that I've provided, they should be sufficient.
Okay, because let me know if you want this put up, I can put this up, but
Okay.
they have the other photos on their
Okay,
tablets
I think
already.
there may be one or two, but I think we're good.
Okay.
Okay, you ready?
Yes, ma'am.
Okay, our tax increase quite a bit because of the loss of the ag timber exemption. We were under the understanding that our taxes were frozen in 2006 due to my husband's disability, regardless of the exemptions. I guess we misunderstood that. I did call the tax office at the time when I got this, not the appraisal office, to find out why. And they referred me over here, and I made a couple of phone calls and never get to talk to anybody. Okay, my second thing is on the ag exemption, we have a neighbor that burns everything down. And in July of 20, they burnt all of our timber off the back of our property, and our fences were damaged by the fire department and the Texas Forestry. And they have not been put back up because nobody wants to claim responsibility for that. And it's an ongoing issue with this said neighbor. My animals and livestock there are pictures, which I have them pinned because we have a front portion of the property, which the larger livestock are in. And then I have pins with all of my other livestock. I have goats, chickens, turkeys, geese, ducks, cows, donkeys, horses, and they are listed on there as to the quantity of that. They are used we kind of like to live off the land, so we have our meat, eggs, milk, etc. Our horses are to care for our animals and keep them rounded up. We also have rabbits. Also attached is the tractor supply bill for the year of 20, which alone shows you my feed expenses, fencing expenses. I did have to totally redo the front fencing after the back was messed up. So I mean, the front fencing is all brand new, and that's what I'm trying to establish. There were pictures on the here and also on the thumb drive, which show you this is a small farm, but it is family ran. My grandchildren and children are very active in it, and we have 4-H, FFA, and affiliations. And let's see, and then the property value increased across the board. It didn't matter what we used for ag or not, it was dropped. We also had the homestead, ag exempt, and the disability on there. And basically, we're requesting to have our ag exemption put back on our property. And I rest my case.
Okay. Mike?
Cross-examine. In my evidence, you'll see a difference between, there's two different pictures, and it goes into my question for the property owners. If you look under ACAD evidence, you'll see two primary pictures. And this is aerial imagery from the difference between 19, which is the second picture, but then the most recent picture, which is 1/1 of 21. You'll notice that this, again, looks to be a sand pit. The board has heard cases like this before where, in our opinion, the district's opinion, that the use has changed to that back property. You can see the difference in the pictometry imagery. The second picture, which is the bottom picture, that's a 19 picture.
The first picture is.
The first picture is 21.
Okay.
The second picture is 19. I showed 19 because it was definitely active in 19, or it was applied in 19. It was put on the ag watch in 20 because we thought we saw some stuff going on. And then in 21, you see the pictometry imagery that's there. And so can you describe your sand operations? Because you've got on this photo right here that we have two short bed dump trucks, and you have an excavator and what appears to be just a sand pit operation. What do you have back there?
Basically, the first time we started out digging the water for our animals. Then with the neighbor burning everything down, we were working with the Texas Agri Extension to do possibly catfish stocking. Here's mine. I did not present this because I don't think it was a
Okay. Alrighty. The late nature, the subject property owner, it's all start going into my evidence. The subject property owner was given notice prior to the notice period that they were actually given another notice that their ag was going to be removed for a portion of their property or all of their property. And the reason given was that it looked like a sand pit. They were given notice. They did not protest. So now we're at this time of the year. The only avenue that they have is the 1 quarter over. I do want to point out that they still have their homestead and they still have their disability in place. Go ahead. If you have a question, it's okay.
Okay, I was under the impression that taxes were frozen because of my disability.
For the portion that's associated with your homestead, yes, sir. For the portion that's associated with your homestead.
For the house and
For the house and the 1 acre that was attributed initially as your homestead residence. If you'll notice on the card, and this is on the card, there's 2 sections of land. It's a 1 acre tract, and then there's a 10.24 acre tract. And so obviously you can't have a homestead on ag land. So they're delineated, they're separated. In this year, we removed the 10.2 acre tract as ag because it looks like a sand pit. This is not the only one that we removed this year. There were several that we removed this year because they were running similar operations. I mean, I don't know what to think other than there's an excavator and there's dump trucks on the property in the back. So I'm gonna go ahead and make my case. As far as the 1/3 over, the appraised value is really based on a valuation that has to do with the overall appraised value, the overall market value. We have a market value of $248,000. Now, I want you to understand that the market value for the land is there's $128,000 that's attributed to the land that was formerly ag, but you have a value, and then if it's in productivity, it has a productivity value. So that's the thing in question, is this part in ag? In our opinion, it's not. If you go into the, after the second page, you'll see the GIS, the pictometry imagery. On the other one, this gives you a comparison of January of 21 versus January of 20. You could see that they're starting an operation. And then here, in this other one, there's a comparison side by side, January of 21 versus January of 19. And so you can see that there's a general something going on. When I'm looking at the one in 19 and the people that have applied for ag and they have, in the past had ag, there's nothing that tips the appraisal district off that says there's anything weird or wrong with this. When you look at the side-by-side imagery and you see excavators and dump trucks and obviously sand piles and pits going on, that led the district to remove the exemption because we felt like it was no longer primary ag. Moving on, the thing in question for the comparable sales, which is really market value for the subject property. These are going to be sales in and about the subject property's owner's area, which is just what's called the Campbell area. You got Murphy, you got Jacoby, you got Johnson, and then you've got one on Bypass. If you look at all of these sales, they're sales of, they're going to be sales of similar tract sizes or maybe even larger. And there's adjustments for those valuations. There's also adjustments for the valuation of the houses, but you could still see that the median value of $258,648 exceeds the market value that's currently on the subject property at $248. So from a sales comparison approach, the market value of other sales, and I forgot the weeping willow one, the other sales in the area support the valuation of the property. The thing in question was, is it ag? In our opinion, it's not ag anymore. It looks like a pit. For all practical purposes, it is a pit. On your comparable equity grid, you can see that, again, these are not necessarily sales, they're just how are other things appraised on a total market value basis. Again, if I want to point out that if you go back to the card, which is number 1, the very first page, I'll finish up whatever my time is.
Okay. All right. You have, the homeowners have 2 minutes for cross-examination and 2 minutes for rebuttal. So I'll give you 4 minutes.
Okay. How can this not be ag when we're a farm? And my animals are normally back in that portion, even though they're digging right now to dig these ponds and stuff for them. They're normally there, but because of this fire and fences are down of no means of my own, because of the fire, the neighbor not taking responsibility for the fire, even though he's been fined multiple fires, I feel like I can't put my animals back there. They're going to get out. And I'm waiting to find out if he's going to fix those fences and going from there. And
So is
that's
that land? Your timber was all burned down, so that's how it became sand.
It was timber and grasslands. The grass was held for my cows to eat. There's nothing back there. So now it's sand. And with the fences down, they can't go back there anyway. And
Are you operating a sand pit situation?
they are
there?
digging my ponds to stock for this catfish program that we're working with Texas Ag Ride
Oh, I see.
with to start the fishing and so forth like that. We're trying to get more into the ag because like I said, we how to be self-sufficient with all of our animals, and fish was the next thing because it's the newest diet in the world. Everybody wants fish now. So that's where we're going with that.
Just the fact that they're in the process of making that back into ag land qualify for anything?
When did you start the fish program? Have you?
Right now, we're
have you
doing,
When did you turn in the official paperwork?
I have not turned any fish, this is just the baby steps right here.
I guess the backup question is, is all the sand still on your property? Have you sold any of your sand?
We have, the people are digging it for the sand.
So,
They're doing the work for us.
so there's an exchange of services for a compensation in the form of sand. Got it, okay.
Our property value doubled from, well, like 120 to 248 in 1 year. Or did I see that wrong?
We did not see that.
Well, it's because the ag went away and it got added back in. So that's why you see 140 from 12.5 to 140 is because the 128 that was ag was added back into the 12.5. I'm sorry, Mike.
Yeah, that's exactly right. You have $52 an acre that was, and I'd have to look at last year's card, which I don't have in front of me, but it's somewhere in that general neighborhood that it's gonna be, $100 an acre or something like that. So if you had 10, that's $1,000. But the delta is between 128 and the one, and so there's $120,000 difference. The market value was probably real close to the same. I'd have to look. Maybe,
Actually,
with your permission, I'd like to ask,
What's his name?
Scott.
I understand your
Okay,
explanation.
okay, sir, then I don't need, okay,
Now that changed.
okay.
I have a question. Can I ask a question?
Sure. Yes, you got 30 seconds, about 30 seconds left.
I don't know.
Yes, go ahead and ask it.
You have a question?
My question would be to you, if when that pond is complete and fish are in there and all that, does that then qualify as ag? land?
I haven't had one of those situations. I can't speak on a future exemption.
I was just wondering if that was then.
I have one more question. Can I go ahead?
Sure.
So in your farming operation, what kind of income do you have off selling your animals?
I haven't sold any of that.
Okay.
We, like I said, we are self-sufficient, so we eat the eggs. What we don't eat, we give to neighbors. Same with rabbits, goats, anything like that. This is not a farm that we pull a profit off of. That's not our intent.
looks like from your pictures you did. Show animals.
We do a few.
The property and what, they only have one entry for the ag stuff, okay? And I guess one acre is carved out for the homestead. But it would seem, and that 1 acre is, it seems like it's in the middle of, I'm guessing it's in the middle of.
That's correct.
So the front part towards, between your homestead and the road, what's that used for? Is that where you have your animals now?
That's where I have them right now, until I get my fences back up and then get back into those back ponds.
We may need to find out how big that is.
So Mike, you have 2 minutes for rebuttal.
The thing of the question is the motion correct for 1/4 over trade. So where I was going or where I was at was the equity grid. There's other comps here that are on Johnson Road. These are all on Johnson Road and they support the value from an equity standpoint, meaning that the overall market value is supported for the baseline price per acre in the similar homes appropriately adjusted. The thing under question is just like, we basically have the 10-acre minimum that's in ag. If you remove the back acres, they're below that threshold typically, and that's the reason that the ag was removed. Historically, it was carried as 1 acre for the residents and everything else was ag. I don't know that I'm even necessarily disagreeing with where they're currently keeping the animals, but that's news to me. I mean, this is the evidence that's being presented today. But the back is definitely a different operation. I'm left with an enviable position of saying that, hey, this is what I see from an aerial imagery. It looks like it's not an operation. And then secondarily, they bring in you information for something in the front, and therefore now you have to consider, is that being used for ag? And if so, does it meet the minimum standard? A minimum standard is 10, it's not gonna meet that threshold. It's just a bad situation. Yeah, but having said that, this is the case that's before you today.
Okay. We'll go to closing. So you have 1 more minute to tell us anything else that you want to tell us.
Okay, 1 more minute. As soon as my fences are back up, my animals are gonna be free to roam. So that would put that back in my ag, with or without the pond, because there's plenty of land out there for them.
Then would we have to wait, do it for 6 years to get our ag back? Once you lose your ag?
Well, let me ask a question. When did the fire take place?
July 20, we were digging the front pond for them at that time.
So you were digging a front pond.
Okay.
Sure. You were digging a front pond, and then the fire happened, and then you dug more. Is that
Because-
right?
Yes, because we had no more timber, no more grass, and plus the state used that pond that we were digging to help put out this fire with a helicopter.
I'm looking at I guess I got 1 minute.
You can go.
I'm looking at this comparison from 2020 to 2021. Obviously, there was an operation here. You've heard cases like this before. I've made decisions based on an operation like this. And I said, hey, listen, you can't have it if it's a pit. If it's a sand pit, it's not ag. As far as future intention for the subject property owners, there's a 2-year window for them. They lost ag in 21. But if they're claiming that they had ag in 20, they can have a 2-year fallow period. There's a 2-year fallow period associated with the ag 1D1 special evaluation, which means that for 2 years, they don't even have to have animals on. Like I had 20 acres, and I can just let it heal up. I can let the land heal up for a 2-year period, but it has to be, a fallow period. That could be applied to this situation, but I'm telling you that if you don't get your fences up, and you don't get animals out there, and I'm going to remove it again.
What would that deadline be in terms of the timing?
They got to have it before January of 23
January of 23.
for a 2-year fallow period.
Hmm.
I mean,
What year, 2020?
well, I mean, it's not just as soon as possible is what I'm saying. Just as soon as possible, get your fences back up, run your animals over there, reapply for that kind of stuff. But currently it is not. I mean, that's your decision to make. That's your board's decision to make.
I have a question on timing. The fire occurred in July of 2020. And when did you start this operation to get into the catfish?
The first pond was originally being built for our cattle. Nothing to do with this catfish farming.
Mhm.
After this fire, it's burnt to the ground. And there's still, you can go out there and see all the way around us where it was burnt. It burnt Johnson Smith Road all the way to Armstrong and almost half that side of the road. So with that being said, the guy was there. He said, is that all you want us to do is the one? I said, go ahead and do another one. That way there'll be plenty of water. And then we started talking to my daughter, which is she's a graduate from A&M, started talking to us about this catfish production in the ponds. And I'm like, that sounds great. And so we went ahead and let them do the footwork on the second pond. And that's where we're at right now, just doing footwork and looking into it and getting our education on it before we dive headfirst into it.
So I can see his-
From a practical legal timing standpoint, the ag special valuation was removed in the year of 21, which is a January 21 evaluation. And this was based on, my looking at it. So for they're bringing you information that says, hey, listen, we're trying to get it back. We're trying to put up fences. The clock is already halfway. Like this is halfway, like basically in 20 days, it's halfway done. If they don't get a fence back up, then.
If the fire had not occurred, would you have proceeded with the catfish operation?
Not at all.
Okay, because I'm looking at the 2020 picture and it looks, you can see them moving what looks like sand around and stuff like that. So it's kind of a transition period.
So you were already digging the pond.
We were
Yeah, right.
digging the one pond for water,
Yeah,
yes.
at least
Really
in
similar
the
to
beginning
the
of.
case we heard earlier in the summer with the fellow digging for his. I don't remember what it was, but he was digging for wildlife exemption.
So they can let it go for 2 years. They have 2 years to recover. Is during that 2 years, is the exemption, is the ag removed? Or does it stay on it for the 2-year period until
It can go either way. I mean, a person can come in and say, prior to the year, like, let's say I'm a rancher and I have 40 acres and 20 acres is ag. I can come in this year, I can come in January and say, hey, appraisal district, I'm not gonna have any cows out there this year. I'm not gonna have any cows out there for 2 years. My fences are up. I'm gonna let my grass replenish. You're able to do that. That's good operation. This is not quite
and
that.
the ag exemption
Ag
remains
exemption remains in effect.
during in effect?
In effect, this is not quite that same thing.
But aren't they really kind of in the same situation, or
They can.
they
be.
had a way to let the grass growing and all that, but they still kept their exemption?
The basic thing is that they don't, right now, they don't have animals in the back. They have all their animals in the front. Therefore, they're below the minimum threshold. And therefore, when I'm looking at this, it looks like a sand pit.
No grass.
No grass.
No,
They
there's
burned
no.
up.
Yeah.
In
But,
20.
and that's why I was focusing on the 2020 picture, January 20, which to say, if the fire hadn't happened, this is just a transition from, putting a pond in there and that's that.
It's just that they're trying to obviously maintain the ag exemption. They're just in the process of trying to get that finished.
We on our time. then?
Yeah.
I'm of the opinion that it is an ag operation of some sort of, specifically what kind is not our.
I agree, just from the standpoint of, it's a transition period right now, and they may be back in another year.
I have a problem with that.
Okay.
If they were letting the grass grow back, that would be one thing. If they actually had applied for the permits or whatever required to do the fish pond, the catfish pond, that would be one thing. But they haven't. They haven't applied yet for the catfish pond. They're considering it. That's that's what we're told, but they haven't applied yet. And the damage that they've done to the land with the sand operation, there's not going to be grass growing there for a long time.
That was the point. The point is to have ponds, not the grass.
And then not ponds, they're water tanks. In Texas, we call them water tanks because it's for water
But
livestock.
the entire area back there has been just denuded.
but not because of the sand operation, because of the fire.
Oh,
I mean, the sand operation didn't help, but at the same
It
time,
certainly didn't.
no, but, and that's why I asked, if the fire hadn't happened, what would the 2020 picture look like?
And if
Okay,
the pond was already. That's what they're doing to correct the situation, because of having lost what they lost with the fire. It would then put it back, I would think, in an ag situation.
absolutely. Which then factors into this transition period as well.
Right, in transition period,
Yeah.
just like you would be if grass was growing. To me.
2 years, so that's July 20 to 22, right?
Oh.
Although it would be not until the 2023 appraisal, but
How long until, you don't know about your fences because you getting lost or anything going on with that?
We've talked to him over and over. It's Dr. Edwards. And it's like beating a brick wall.
Are you going to get that resolved? Is that, will there be
Evidently.
fences there one day? In the next
Yes.
Soon?
Very
We're
soon.
hoping that he had to pay a fine. So we thought that they were gonna go ahead and replace the fences.
Did they
because
cause a fire?
They did the fire,
he
and
was-
more than
they
one
gave-
fire,
They
actually.
fined him for the fire. So they're showing he's guilty. We had heard from, which it's all hearsay, that he had started the fire on purpose because he had so much junk back there. It's all hearsay, but he had to pay a fine. So
It's about every other month he has a fire back there.
And there
This
has
one is
been-
not a-
there's been several fires back there.
My view is that they, until they show that they have fences back, that they have the animals back there, or that they have a fish pond back there, that the ag should be removed until they show demonstrable action.
Or put it in fallow. Or put it in a fallow situation, yeah. Fallow.
Oh, fallow.
What does that mean?
The term.
What he was
fallow-
just telling you,
the term-
what he was telling you about saying, I need the land to rest until I can get grass growing back there,
Oh, okay.
until I can get pines built, until I can get fences put back up. I'm not gonna put cattle on this or livestock on this. And I have 2 years to set it right.
And another thing that everybody should be aware of, in the application, there's, like when a person first applies, for a 1D1, they have to talk about a 7-year period. They have to describe that they've been in use or out of use within that 7 years, but they only have to qualify doing production for 5 out of the 7. So you could do it, and that's why I made the statement, and I'm making it to you, that it could be either. If this board denies, like they say, hey, it should be removed, and they agree with the district, you still have time to say, to get your fences back up and say, hey, Mike, I reapply for my ag exemption, but you gotta show me that back acreage is being used, at which time you can say 5 out of the last 7, because you will have fulfilled that statement. This board can actually just agree with you that it's just lying fallow as no fault of your own. The district's position is that it saw a sand pit. So you get to make the decision, unfortunately.
No, if they were able to show the next 6 months or whatever,
If you,
that was,
if
that
this
was
board,
operational, would that put the ag exemption back on it?
with an application, so there's two outcomes right now, right? What they petitioned is saying, hey, I removed your ad, the district removed their ad. So one, you find in favor of the district and the ag continues to be limited. In which case, they still can actually reapply with the fences back up and saying, I got cattle back there now, Mike. And I can fill this out with good faith and sign it because 5 out of the last 7 will still be valid. Or, Mr. Schweitzer, they can agree with you and just say, hey, you're letting it lie fallow for no fault of your own. So that's the unenviable position that you're in right now.
So they could reapply with. If you remove the exemptions removed, they get the work done and reapply do they still have to wait 2 years?
No,
or would
no.
it become effective right away?
No, because they can
It
say.
would be for, it would be for this year.
They could
next
say,
year.
they could say by, in December of 22, you come in, you have pictures, you have your fence, you show me pictures, you show me cattle back there drinking the water or whatever. And on your application, you're able to actually say the current year 22 cattle, 21, no cattle, 20, no cattle, right? Because in 20 and 21, you didn't have cattle, but in 19, you had cattle. So on your application, you go 22 active, 21 inactive, 20 inactive, and then all the previous year active, you still meet that qualification. What it does, if they remove your exemption, it actually puts a burden on you to actually get the fence done. And if they grant you the exemption, there's no burden for you to hurry up and do that. And then I have to remove it again, and then we get to talk about this again.
But we had cattle at 20.
Yeah, I know, that's what I'm saying. That's my point. In 20, so again,
And we have cattle now, but.
yeah, in 20, so you have 1, 2, 3, 4, 5, 6, and this is just for informational purposes. In each of these years, you're required to tell me if it's active or not. So again, I'm just gonna throw a hypothetical out there. If they agree with me, then I deny the exemption and they still hold that up. Then that means in the year of 21, which is year 2, because we're talking about a year in advance, it was inactive. But in year 22, you're there. In 23, you're there. Basically, January of 23, you're there, right? You've got fences up. Then you say active. But in 21, it was inactive. And in 20, this is 23, this is 22, this is 21, which we're talking about right now. This is 2020, 2019, 2018, 2017. Active, 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 active. If you turn something like that into me, then that would still qualify. But what it does is it makes you in January of 23, you have to say, I'm here, my fences are here, these animals.
But in the meanwhile, if it went the way you want it to, in the meantime, we'd still have that 300% increase in taxes.
That's correct.
Which is outrageous. for
That's
us.
correct. That's correct.
How much fencing are we talking? Are we just talking about the strip across the very back?
No,
or
the back
the
is,
back of
the back one is a double fence and they didn't run it over. There's
The complete
probably 300 or
side,
400 foot on each side. Well, no, go ahead.
the complete side against the person that started the fire department totally knocked it down to get access to put the fire out.
And that's on the side that,
That's on the east
where
side.
from these pictures, I can't
It's
come
hard
up
to
with
tell.
north, south, east and west, but
It's on the east side against the neighbor's property.
They're 1,360 feet from the road to the end of the property. And I would say,
not the trailer park, but
No.
the one
No,
that's
I
kind of
would
got
say there's
scattered
probably
stuff.
800 foot of fence that's gotta have to be replaced.
And then on the other
Good
side
afternoon.
is about 150 to 200 foot. I mean, that's where the forestry went ahead and continued knocking it down to put out embers.
Yeah,
And Mr. Kress.
so you want me to make a motion?
I'm not sure.
Discussion.
I'm not sure where we're at. We're
The district's position was, if I understand it correctly, the district's position was this is a sand operation. It's not a sand operation. It's been stated under oath, it's not a sand operation. It's
Digging
something
operation
else
for a pond.
entirely,
Well,
which can be
It might
ag.
be something else.
It
It's
can,
not.
hang on.
Okay.
It can, let me finish. It can be like we've seen before and like we've ruled before, that it's water. They're holding water for wildlife or for ag livestock. Does that really matter?
Are they getting compensated for their sin?
the,
You're getting compensated. It's, it's a barter kind of deal, but it's.
I understand, but it's
you're
not a
getting
sand
compensated.
pit.
Sand is kind of throwing everybody off.
They
It's just-
lost the ag exemption because it's a sand pit. It's not a sand pit.
It sure looks like a sand pit to me.
Yeah, but-
They've already stated
They
under
said
oath
that
that it's not a sand pit,
sand.
that they traded the sand for the work.
There, that's compensation for sand. That's compensation for sand.
They're not selling sand, they're not digging it specifically.
They'd have to do
for-
something with it at
They have
some
to get
point.
rid of the
anyway.
sand, so.
It would have had to, then it would have cost them money. The end result is gonna be a tank.
And sand that was sold for compensation.
Wasn't sold,
Wasn't
basically,
sold.
they traded it for.
Bartered.
Barter situation.
I think you're getting into a whole other conversation here. It's reasonably simple.
I'm not convinced that with the animals listed and everything, that this is a viable farming operation. I think this
Doesn't
is
have to
more
be.
of a-
Doesn't have to be. They can do, they can do
show.
show animals. There's a whole lot of things other than bringing cattle to market. 10 acres, it's very difficult to show a profit or to even show any sort of, it's 10 acres is
I think the reasonable way to handle this is the way that Mike has laid out.
oh, absolutely. Mike gave them the solution.
The-
Absolutely. The solution
You
is there,
take-
800 feet of fence, sprig some coastal, and you're back in business.
Well, and finish the pond,
But that doesn't,
which is part of what's going on, so you have to.
Well, I
consider
think
that.
it's,
Get fish in the pond and
that's neither here nor there. The pond, building a pond is part of ag. That qualifies for ag. You can build water. You don't have to buy water to be a farmer.
But
Catch your own water.
once again, Mike's way of doing, a suggestion of 2 years off and reapply with 5 years active and 2 years inactive, they can reapply and get it back again in 23.
yeah, but what about the interim period of time
20 and 20, well, 21 and 22.
where they have paid
They've had some tough luck
taxes,
here.
where they have paid taxes on an elevated value or an elevated appraisal, market value?
Through no fault of their own, really.
Well, be that as it may,
That's not,
and I don't know if they can recover, I think they can recover that, but that's still, that's an out-of-pocket expense that shouldn't have happened.
well, shouldn't, would have, could have, it did happen. It's,
I get it.
they're digging sand. It's not, there's no livestock there. There's no fences. They get that fixed, they reapply.
I understand they can reapply. I don't know how it goes back retroactively to deal with.
It doesn't go back retroactively. Whatever you decide today is the value associated with 2021.
Well, what you also said is if it wasn't completed by next year, you would remove the ag exemption again. Or try
Well-
or suggest removing. Or
Okay.
remove it.
So if you remove it today, it stays removed until they reapply. If they reapply prior to January 1 of 23, and they show, it's okay. Can we get some? It's okay. It's some paper towels. And show that they have ag fences up, then they get it. If this board says that, hey, it is ag, then I have the burden of like trying to say that it's like, do you have fences yet? And then we're
20
doing this
days.
again next year.
So you would deny it again next year.
If they don't have ag again, if they don't have ag in the next year, I'm gonna deny that again.
That's what I'm.
Yeah.
And then,
okay, we ready for a motion?
No, not yet.
Okay.
I don't know, where are you at?
I'm not in favor of removing the ag.
Scott?
Yeah, I'm not either. And if it gets removed, if they pull it again next year, then we'll talk to them again next year.
I'm also not in favor.
I am in favor of it.
Yeah. I think we should go with the plan that was put forth.
The plan that was put forth.
Which was to reapply.
Reapply after
2023.
2 years.
Yeah, and I don't have, my angst with that is the fact that it's increased significantly their tax liability during that period of time, and it's unclear that they can recover any of that. And,
They can't. It is what it is.
well, but you're right. Okay. So this exercise of going back and showing that, okay, in over the 7-year period, these 2 years were inactive, and it was not, it would not have caused the ag exemption to go away during that 2-year period of time. I don't know how that works out when you go back and reapply.
Yeah, and I'm just not saying, I'm not saying it's nefarious evil plan, but let's pull some sand out and be a mining operation and not an ag operation. I think it's a bunch of bad luck that it happened in the middle of the fire happened in the middle of putting the pond in. And
But if they were doing nothing, and that was truly a sand pit to make money out of, that would be a different story.
sure, there'd be a big sign out front that says, whatever excavating company, and there'd be a.
But they've had the opportunity to put the fences back and they couldn't. or wouldn't.
That would be their money. It's not, it's something that happened not because of something they did.
Well,
That doesn't matter here.
it doesn't matter. They have the opportunity to put the fences back and put the cattle back in.
Been a year and a half and they haven't, so.
We've replaced the fences in the front. We haven't got the back completed yet.
So you're wanting obviously the neighbor to pay for the fence.
We asked him
Yes.
to, but if he doesn't, it will be our responsibility to replace them. So we started at the front working backwards.
So you're trying to recoup the fences as
Yes,
we speak.
Yes. You can see in the
It's
photographs.
interesting, but it's not there.
Yeah.
It's not there.
Take it off.
Make your motion, see where it goes.
What?
So,
I'm torn because, before you do it.
I am too. So that's a tough one.
Yeah.
I know they're working on it.
Had a year and a half. Well,
A year.
yeah, I mean,
Well, yeah,
the exemption was removed beginning of this year.
Will be for 21 and 22.
The exemption was removed for 21.
For 21, but it will probably be removed for 22.
If we
If we
leave it
rule,
in
if we
place.
rule to remove
Yeah,
it,
so they have to have it removed for 2 years.
No,
This year and next year, they can reapply in 2023
they can reapply for
anytime.
22, yeah.
does the fences have to be done by January 1?
So here's the thing, if the fences aren't done in the next 20 days, I'm removing it for 22. And so we're in
20 days.
Well, that takes us to the end of the year.
That it takes us to the
January
next year.
1 is-
Here's the reality of all of it, and I'm not being obtuse, I'm really not. I'm just telling you, I have a January 1 appraisal date, and just like you had the opportunity to like from July when the fire happened, you had all the way until the beginning of 21 to do the fences, but you didn't. And so I understand your explanation. I'm not even disagreeing with you. I'm not. The fact of the matter is there's no fences in the back on January of 21.
Okay, so we'll argue,
So,
there are fences across.
but I'm not arguing with you, sir. I'm really not.
I'm sorry.
At the beginning of January 22, which is in just 20 days, there's probably not gonna be fences in. So even if this board says, hey, we want you to continue with the ag, that's all fine and good.
They'll just take it off in 20 days.
I'm gonna take it off in 22, and here's the reason why. Because you still don't have fences. That's the whole thing. I need fences and animals back there. That's my position.
Mhm.
And it's okay that, I understand your plight, I understand your situation.
The fence is missing from here to here.
Again, get it done and put animals
Get it
back
done in
there.
20 days and you're all right.
No, but understand, it doesn't matter. Like, I'm really sorry that I set you off. It was not my intention. But do you understand I have a January 1 appraisal date. So I have no fences on January 1 of 2021. And I have probably no fences on January of 2022.
Let's proceed.
Okay. I'm sorry, sir. I didn't mean to upset you.
You're all
So
right.
Go ahead.
I'm gonna make a motion then on case ID 2021-2295, account number 65177.
Whoops. I don't think
No,
that's
you're
it.
down one.
639.
Oh, sorry. Make a motion on case 2021-2296, account number 63967, that we hold the removal of the ag exemption from the 10 acres of this property. The homestead exemption, everything all stays.
A second.
All in favor?
Aye.
I'm opposed.
Let the record show 4 in favor, 1 opposed. And we are done. Hearing is closed.
Next hearing-
So if I get these fences up in 20 days, you'll make this right. All right, I'm
Sir,
sorry. I
sir.
walked out.
Mr. Schweitzer, if you get the fences done in the next year or 20 days and reapply, you'll have good evidence that you're in ag.
Okay, it's just been a hardship for us all the way across.
I'm sure
because
it
of all that.
I'm sure that has.
We've had to buy hay and all kinds of stuff, and he's actually over it, because we actually had to move cattle back and forth, and it, with him being disabled, it's a chore.
I'm sure that it is.
So, but thank you.
Thank you.
Thank you.
The next case number is 2295. Name is Dustin Reininger. And it's account 65177.
He's here?
He's here. I can bring him on back.
Bring him on
It's,
back.
no wheelchair,
Oh, wait.
so I'm gonna make sure.
It was a 2-minute.
Sure. And I don't know if he'll be able to actually navigate back here. We might need to set him
Just put
up
it right
over there.
Yeah, we'll see. Here, move this back.
Val, will you continue when you have a second here?
Sure.
Is this the way he wants us to proceed right now?
Like to sign this right now?
No. So that just, I wanted to know, because we're gonna do this case next.
Okay.
Then when we, I don't know if we should do that. When we do the chief appraisal motions.
They were not happy.
Do go through that listing. When we have hearings,
They're okay then?
Jim told me that I should
Yeah,
use this.
It's,
And actually, I'm.
Down the track.
Probably use it for every one of them.
It's tough.
it's a
The new
it's a very
chairman,
tough
I think
one.
in the new
I'm
year,
trying to figure
have the new
out, how
chairman
do I
sign.
set this? I didn't do anything
No,
to
you
make
wouldn't
it,
sign any of this.
um,
This is what
to
Charlie would
do
sign.
a value, it doesn't, I didn't
Gotcha.
change anything. And I'm wondering if
And
I
that's
should
just
do this, or if I
one.
need to go into values.
I was
and
gonna
set
have him
the
sign
value.
that.
It didn't change anything, they don't do anything.
Right.
I thought we were
Alright,
doing
do you
it
want these here for your
before we
records?
were in,
Well,
in this situation.
I wouldn't have minded hearing it again, but it's gonna be 20 days before, I mean,
It's gonna happen again.
yeah, because
Because I'm
he's
I'm
kind of got no
concerned that
option,
it's gonna do,
but to take it off again.
Val.
Yeah, sorry.
No. I didn't do anything
Sorry,
on
it's not
values,
really-
so we didn't change it. I mean, they didn't change anything. And then.
Yeah, we didn't
the
ask about
Settings
that.
indicate that should be closed, and in this case, we just usually say
Right.
yes to this, and it closes it.
And that's fine.
But I didn't do any
Like, we don't need to
supplement or
supplement
anything
it.
because of this,
No.
because like nothing happened. I mean,
Right, let's not supplement it. It's fine.
oh, do you want to supplement before closing?
No,
He's gonna do it
we
again.
don't. It's fine.
It's a day job. It's a 2-day job,
Thank you.
2 full days.
Well, I'm sensing too that they don't have enough money
Straight
to
line fence.
take
And
the
that's
guy, to sue the guy.
And
and
that's,
stuff like
well,
that.
of course, that's what you're going to do.
I don't believe they're gonna show,
We'll see.
I don't believe that the one that he was planning on representing.
I- He's there.
I think,
Robert, you still there? I don't know. He must have gone to the restroom.
Nobody walked out.
Do you think they can't fit back here?
I don't know, I just went ahead and brought this little table in and tabled it over here.
Yeah, I
Okay,
can.
so I'll go ahead and,
Their mobility.
handicap. Yeah, it's handicap, but he's
How's Cindy?
good. Good. Yeah, we went to Indeed Monday.
She what?
We went to Indeed Monday and blood test to check on her
We've
stem cells.
We've talked about this one before.
Yeah, she walks. She walks an hour a day on treadmill with about 4 miles an hour, 3.5 miles an hour. Just like that. Good clip, you know.
I don't know if
Probably
it's
15
that
minutes.
guy, but I do remember,
In terms of being.
it seems like
we're thinking you can probably go back there.
She
but-
had
there was an issue with
Right.
documentation.
Right.
or,
She's
blah,
got
blah,
another
blah,
one,
thing.
virtual one, but that's pretty tough.
Right over here.
Back in.
You got it made and shady.
Good.
There's no, this is the,
Would you like to
right,
set
this
up
is the
right
other
over here?
person.
I'll just.
Right, that was the
Okay, I've
evidence.
got this, if you
What
want
happened
this,
here?
if you want this.
Which.
That's hot,
It's just
so I
your
cut it.
evidence and my evidence.
Hey, where's your sweater?
Your evidence.
Where's your sweater?
this
Which one did
ACAD
she
evidence.
say? This one?
Like to see yours.
Yeah, we sent it to you, but I mean, you're welcome to see
Right
this.
here?
Shane Rediger.
Who are you?
Mike Soto.
Chief
Hi.
appraiser. Yeah, I got some stuff here for you on a different thing that doesn't have to do with the protest.
Right, Val was saying that if we can handle that after the protest or after this. If you want this, just let me know at any time and I'll hand it to you,
Okay.
but I'll just leave it right here.
That, I have that, I just.
Okay.
Wanted to see what you got. That was it.
Is Jim still on or is he off?
Jim on the,
Zoom?
Yep.
I am here. There.
Jim, I may need you just for a little bit on this.
Okay.
Okay,
Who is Joe?
Jim is he's the counsel for the district.
okay, we're ready. We're opening a hearing on case 2021-2295, account 65177. This hearing is being recorded. What is the purpose?
On the paperwork that we see for today's hearing, it says Q6 exemption denied, modified or changed, but on the original protest form, I guess maybe this isn't the original protest form. He's got Q1 and Q2. And then he's also got property description is incorrect, if I'm in the same.
It says exemption is denied, modified.
You're going to 65177.
Yeah.
Make sure.
324
Yeah,
Club Lake,
651.
Vinegar.
65177.
Did I pronounce it correct?
Yes.
CAD evidence.
Oh, you look at the appraisal district. Okay.
Yeah. Homestead application.
What's the question?
Well, it's unclear what's being protested.
Protested here.
Well, on the protest form there's a discussion at the bottom.
Ask Dustin. I think he knows.
Form 50.
Initially, I wanted to have a hearing about the taxes. Because the evidence, they were using my brother's house next door as an example, but his house has been completely rebuilt from the hurricane. The one I'm living in was built in the early 1970s. It's my dad and I lived there. My dad's 95, I think now. And he and I drove over here today. And he had given me the property. And so that
Why don't we wait on that until
yeah.
we open the case and
But what
We
this
just
is
need to know
about,
what's under protest.
Well, it's on the form here. This is
Yeah.
what's under protest.
the ID they didn't want to grant me the exemptions for the homestead because my driver's license is expired. But I have an expired driver's license, social security card, and I also have a Texas current Texas Department of Health and Human Services card for my medical
Okay,
disability.
so you've described two things. You've described market value and you've described an exemption. We need to know which one.
We're here for the
exemption.
Exemption. I
Okay.
would like to have a protest at some point for the property value. That was denied. But this, today, we're here for the exemption.
There we go.
Just a little bit of reference, Mr. Reiniger did protest in the past for value, is that correct, Val? And this board, it was like a late request, and this board denied the protest, the late protest for market value. You do have in front of you a notice of protest in relation to an exemption being denied. That's what's being heard today.
Okay.
All right, so. Who's next?
Okay. We are the appraisal review board that will be hearing a protest today. It's the five of us sort of clustered around the table at this end. Mike represents the district. We do not work for the appraisal district. We are appointed to perform an independent review of your protest. At the end of the hearing, you may complete a survey regarding your experience. Survey may be completed using the survey form and email to ptad.communications@cpa.texas.gov or online at surveymonkey.com/r/survey ARB. Survey is voluntary. You also have the right to appeal our decision. Appeal information will be provided to you with our determination. At the end of this hearing, a document will be created that documents the results of the hearing. It also will give you information and instruction on how you can appeal if you feel as though you still need to appeal, you don't agree with our decision. In accordance with Tax Code Section 4145H, all written material that has not been provided must be provided at this time. Do we have all of your evidence?
Yes.
Very good, sir. Thank you. ARB members who are considering the protest have not communicated with anyone about the protest and are signing an affidavit to that effect. I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of Tax Code Section 4166F.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of Tax Code Section 41.66F.
I, Kathy Hoffman, do solemnly swear that I have not communicated with another individual in relation to Tax Code Section 41.66F.
I do solemnly swear that I have not communicated with another person in violation of Tax Code 4166F.
All testimony from all
Let me-
witnesses must be given under oath. Oh, wait a minute. I forgot one.
Invisible man.
I, Scott Wager, do solemnly swear that I've not communicated with another person in violation of Tax Code Section 41.66F.
Now,
Mr. Reiniger, if you will state your name and read this line.
I, Dustin Reiniger, I do solemnly swear from
My name is Michael Soto, I do solemnly swear or affirm the testimony you shall present to the appraisal review board. Appraisal district is true and correct.
Obligated by the state of Texas, Mr. Green, to ask you if you have a appraiser's license.
Yes.
Thank you. You have in front of you the procedures that we'll use throughout the hearing. You'll notice that there are two major columns on it. And that's because you get to choose whether you speak first or whether the district speaks first. Your choice.
The district. Go ahead.
Okay, Mike, 5 minutes?
Yes, section of the code that applies to it. This is a simple question of an exemption was denied, modified, or canceled. I denied the exemption because the subject property owner filled in, and this is under our information. You can look on here. You can actually look at the application that's here under R. And you'll be able to see, if you scroll through, you'll be able to see his information that he supplied with the exemption application. And the issue is just that it's an expired driver's license. Now, there's not an issue. Subject property owner appears like I don't know if he drives or not, but you can also have a state issued ID, but it has to be valid and it has to be current. The one that he supplied is not current. He's not being treated any differently than anybody else that has an expired driver's license. I would deny them too. And that's the only thing at issue. The other questions in regard to disability rating, those all follow the homestead exemption. So the first question is like, does he qualify? The very first thing is no, because he doesn't have a state issued ID that's current or a state issued driver's license that's current. If that were in place, then we would then look at disability rating or anything else.
So other forms of identification don't qualify. They have
Yes,
to be one of those two.
Yeah, state issued ID or the Texas driver license or a state issued ID. You can have either one.
Okay.
Social Security is federal.
That doesn't,
No, that's not a state. It's not an ID. It's just that's a card, but it doesn't have his picture on it. Those IDs, the state issued ID has a picture on it that says that is that person, and they're affirming that they're the one applying for the exemption. This is an older, the one that he submitted to us expired in 2015. So well over 6 years ago.
was he advised that he needed to have the state ID?
Yeah, he was advised that it was denied on the basis that his driver's license, what he submitted with the application, had expired. And I actually, in the letter, you'll notice this letter is dated to September 20th, 2021. This is your official notice, notification of property tax exemption for which you applied has been denied by the chief appraiser for the following reasons. Your driver's license expired in 2015. The state requires a current valid license or ID card. And that's the only reason the application. That's it.
Anything else? Okay. So, Justin, you have then 2 minutes for cross-examination and 5 minutes for your presentation. So you
Okay. Where in the law does it state that the driver's license has to be, that it has to be a driver's license? Because I can't drive.
That's why it says state issued ID or driver's license. It says both. on there.
So will I submitted a Department of Health and Human Services state issued ID that does qualify.
No, it doesn't.
According to the Texas Department of Health and Human Services, which is a state agency, and the vital statistics, which is the agency, they accept a Texas driver's license that's expired. They also accept a social security card. They also accept my ID that was issued by a
Sure.
state agency.
And that's a great question.
Which is
So
Texas Department of Health and
So-
Human Services.
if you're in are you in a home? Are you in one of those assisted living? Because there is a thing, Jim, correct me if I'm wrong, you have there's a caveat if you're in assisted living, is that right?
That's true. And that would do away with the requirement, but I want to point out that under tax code section 11.43, subsection F, subsection 2, personal identification certificate is defined as a certificate issued by the Department of Public Safety. And it doesn't say anything about the Department of Human Services. So the district's position would be that unless he has a valid personal identification certificate issued by DPS, then the application fails. Now, let me point out as well that I think if Mr. Reiniger obtained the proper certification from DPS, I think he could probably come in and make a late application, at least for tax year 2021, for a homestead exemption. But at this point, the district's position is he doesn't have the ID required by the tax code. In subsection N of 1143 says that except for the one or two things that don't apply here, a chief appraiser may not allow a homestead exemption without either a driver's license or a state issued personal ID. And like I said, the state issued personal ID is a DPS issued ID. So if neither of those documents are forthcoming, then this code section, subsection N, says that the chief appraiser may not exempt the property under a homestead exemption. Our position is that Mike is simply following the law contained in section 1143 by denying the exemption because of the expired certifications.
And furthermore, there's an attorney general opinion about expired driver's license, which the Texas legislature has prohibited the chief appraiser from granting a homestead exemption to an individual that does not possess a driver's license or state issued identification certificate, subsection 1143J4. Further, the chief may not grant a residence homestead exemption based on an expired driver's license, state issued identification certificate, or vehicle registration receipt. 1222. That's 20 of 22. I'm sorry, 20 of 22. So basically, you just need an ID, you file the paperwork, you get the exemption.
But that's not the case, though, because the law says may not, and you're quoting a
Attorney General's opinion.
opinion. So
But-
that's Attorney General's opinion.
But we just quoted 1143N.
Right, 1143 says may not will not. Whenever you're dealing with the law, especially being if you're a law enforcement officer, you have to look at the law as exactly how it says. If it says may not, then you have the authority to either grant it or to not grant it based upon what you're seeing. But if it says may not, then that is a different, that's not requiring you to do something.
I'm going to respectfully disagree with Mr. Reininger's statement. If the code says that the chief appraiser may not,
Then he may not.
it means what it says. There's no discretion in something like this. The chief appraiser's not allowed to tell an applicant with an expired driver's license or DPS ID to say that you get the exemption. Our position is that there is no discretion on the part of the chief, and it would make sense to not give the chief appraiser discretion. I mean, I know Mike wouldn't do this, but another chief appraiser might say, "Hey, I like you. You're my buddy. Forget about the expired driver's license, you're in. And then the next guy comes along and the chief appraiser tells the next guy, oh, you're out, you don't have a valid driver's license. So it would not make any sense that such a subsection is discretionary. May not in this context means he shall not.
If you look it up on the internet, that's not what it says. If you look up the definition.
How are we doing time wise?
He's got about a minute left.
So
Finish your statement.
I'm looking up the legal definition for it, and it doesn't say what he's saying. It says that it's possible that it could go the other way. According to
the lawyer's
may
saying we
not-
can't determine the verbiage is what the verbiage is. And
I'm just looking up the legal definition for it on the internet.
if he was to apply for the ID before the end of this year for 2022, would the exemption then go into effect?
Yeah.
A state issued
If he
ID,
had it by January 1,
when he
2022,
applies for the exemption with the state issued ID that's valid,
whenever.
we'll go into effect. I mean, and then there's a retroactivity of, no, there's not a retroactivity if he doesn't have one.
Lawyer said that it could apply.
I mean, if he obtains a valid ID, I think he can come in and file a new late application once he fixes that. And, he'll be good for 2021. But, I think like right now, he doesn't have the valid certification.
It's a DPS driver's license or a DPS issued ID.
So
You can get,
It looks just like a driver's license.
yeah,
Okay, so it has to be issued by the Texas Department of Public Safety.
according to
And that's where it's written in the.
That's good.
You can apply for that at any time. It's not a hard thing to get.
Yeah, it's just me getting down there. It's real hard. It was hard for me to be able to get here.
Yeah, it's section N, subsection J, to provide a copy of the applicant's driver's license or state issued personal identification certificate on the driver's license.
You mentioned something, if somebody has assisted living, I'm in home, I receive provider services. I have a assisted living in my home. Is that
Well, if you're in a home,
applicable?
are you at this residence, which is what you've
Right.
applied for?
Right, I'm at that residence. I was in a home.
And he has nurses status.
Yeah.
So he still needs a state ID.
That the exception that I think Mike had mentioned earlier has to do with a situation in which a person is not living at the property. And the reason the person is not living there is because that person is in a place that provides medical care, things of that nature. I don't have the section in front of me, but it's designed, for example, for people who are in nursing homes who would live in their house if they could, but they can't because they're in a nursing home. And the legislature decided, I think correctly, to give consideration to people in those situations. But in order for that to apply, the person has to be living outside the property, not living at the property, and has to be in a facility that, and there's like a list of things, medical care, nursing care, things of that nature. But if he's living at home, that section doesn't apply. And our position would be, as Mike stated earlier, if he doesn't have the proper identification, he's not eligible for a homestead exemption.
What's the the law on that?
Section 1143 is the section that applies to exemptions. It talks about driver's license, it talks about personal identification, state issued. You can read it. Again, if you go to the DPS office, and I'm saying this with respect, if you go to the DPS office, or if you apply for the state ID, state ID, and you apply for your residence homestead, it appears to be in order, then you're going to be in business. you know?
Your time. So,
Oh, that's my time?
yeah, we're gonna start your 2 minutes for rebuttal if you need it. So.
Yeah, the reality is that we look at hundreds, if not, on the thousands of exemptions a year. And this is one of the very basic checks. Does the state ID, is it valid? Meaning, is it current? And, they can't bring me something from Georgia, and they can't bring me something that's 6 years old. It has to be a current driver's license. And then if it's not a current driver's license, is it a current state ID? And if those are the very first two checks, and if those are done, then it moves down the list of other checks. So it got denied. There we are.
We talked about this in September.
Is there a way to get ID? You keep saying driver's license, that's the wrong thing. Is there a way to do it? I go into Aransas Pass to the.
I don't know. Good question for DPS.
I don't know. I mean, yeah. Oh.
I think even for your driver's license, you have to be there,
Probably.
so I would assume so, but
Yeah.
it's a good question, I mean, maybe you could
They take
follow
a
up on
picture.
that.
They typically take a picture.
Yeah, exactly.
That's what makes it identification. Picture identification. That's the whole idea.
I just don't understand that because, I mean, here I am with the expired ID before the board. Y'all all recognize me as being who I am. And the mail from the district comes to me and I receive it as who I am. And whenever the bill comes to pay the taxes, I receive it for who I am. I filed a legal homestead with the county, with the county clerk's office. And I followed the law with that. And they accepted it for who I am. And I just don't understand how that I can't get my homestead exemption for a homestead that I already have. I don't understand that. If I already have a homestead.
We don't have a homestead though.
But under Texas law, you can, so I can't get a homestead unless I get it from the appraisal district.
There's two different kinds of homestead. One has to do with the agricultural homestead exemption, which is what's under question today. The other one's the ones he's referring to, which people can have an intended residence, intended homestead. So it's not
And
like the waters.
that would be the one under the Texas Constitution.
Yeah, that's correct.
Okay. And
So Dustin,
that's
you've got-
what I filed for.
You've got 1 minute for closing. Any final thoughts you want to tell us?
No, sir. That was it. There's nothing else I can do.
Mike, you've got 1 minute for closing. Anything?
Yes, there's absolutely something you can do. You can get a state ID.
It's not that easy, sir.
Yeah, as I recall, we dealt with this in September, this specific one too. Was it unclear at the time that they got the response, the response came out in September that you needed to get an ID or a driver's license?
Yes, sir.
It was not clear?
Right, yes, sir. It was not clear.
It's in the letter right there.
Yeah. I'm sorry, it didn't make sense. State requires a current valid license or ID card. And it's unfortunate that, we've had several months now that it could have been remedied and still can be, But unfortunately, I think the law is what it is.
Yeah. Okay, ready for a motion? So I'm going to move then on case ID 2021-2295, account number 65177. that we uphold the exemption for the homestead for this property.
Well,
Yeah, you didn't say that quite
Did
right.
I not say that right?
That we have,
I don't know that you said that, what you intended to say.
Okay, sorry.
that we uphold the denial of the exemption. The homestead, the denial of the homestead exemption based on the lack of government issued or state issued ID or driver's license.
Second,
I'll second.
all in favor?
Aye.
All right, go.
All right, Mr. Reiniger.
Thank you for coming in.
Thank you, guys.
You still have your eye teeth?
The what?
My tongue gets stuck behind it sometimes and
Yeah.
things don't come out right.
It is a pain in the neck to go down there. Make an appointment now.
Yeah, Aransas
We're
passed.
in and out in no time
Yeah,
whatsoever
we
with
didn't
the
do it.
appointment.
The appointment?
Get an
Okay.
appointment?
Because I didn't have the gold star on
I
my
didn't
card,
either.
and then, so I was stuck to
Did you,
low travel.
were you able to get it, an appointment within this millennium?
Yeah, what?
I went, and maybe it's
I
gotten
went-
better.
I had no problem.
I went with my son that had it.
Sorry, right
Were you able to get
And I was gonna jump
recent
in.
appointment? You know, like in other words,
I got one for.
I had to go out like 3 months before I could find an opening.
I went for the next day.
Oh, okay,
Oh,
cool.
you know what? Don't even tell me.
I didn't have a
Just-
problem.
I actually went to
Okay.
Beaver.
Alright.
I went to
Thanks for
the
taking care.
DPS
It's been a
office in
while.
Beaver.
Well, yeah.
Because we had that place in
No,
Brooklyn.
there's no more here.
Nobody there. I walked
You
in.
always go to Beeville or
Yeah.
something.
So we're back to your agenda, right?
No, that concludes the hearing.
Okay.
We're back to your agenda.
Yes, back to the agenda. I
Okay.
think we were gonna ask about changing the order where we could go straight to chief appraiser motions. Hearing scheduled on a chief motion. And I think we wanted Jim to be able to be in on this
Right.
one.
Jim is on pause.
Oh, he is?
Yeah,
Okay.
he's there, but he's muted and
Is there any way to get his attention, I wonder?
there's no video.
Maybe I'll make a quick call.
Oh wait, he's back. Never mind.
So this is, I think, number 9, chief appraiser motion.
Okay.
First one is your permission, Chairman.
Go ahead.
Chief appraiser motions, no hearing. The very first one is the Epps North Lot of 103, 103.8 feet of 2, and I'm sorry, it's chief appraiser
I got
motions.
it.
It's number 9. And this one is, if you look, it's the inclusion of the property does not exist in the form or at the location described at the appraisal for tax roll, and it says 2021. Was it only for 2021?
Mhm.
Okay, it was 2021. The manufactured home was removed prior to January 1 of 2021 per phone call from the property owner, as well as verification through optometry. It wasn't there, so we removed it in the roll. Okay, the very next one is 4160 Highway 35 North, Lot 22 in Fulton. It was the inclusion of a property that does not exist in the form or location in the appraisal district roll for the tax year 2021. The mobile home did not exist at this location in 2021. Another one of the same kind of situations. It got moved out late in the year and we had it on the roll, so we're taking it off. Next one is 509 West Market, inclusion of property for the tax year 2019. Personal property does not exist at 509 West Market since January 1 of 2019. What about 2020 and 2021?
It was not on, it was off the roll.
It was off the roll already. So this is removing it for the year 2019. Again, it wasn't there. Moving on, Bellevue, block 17, lots 14 and 15. There's a serial number and they're attached. The years in question are 2017 through 2021. Inclusion of property that does not exist in the form described. It's removed the city of Rockport as an entity. It was incorrectly added through an annexation in 2017 to both the personal property and the real property. So this particular property is 62110, and the very next one is 63087. And both of those are basically 208 and 210 Stewart Street. And this was right along the line of where the city limit was, and it was included in the city limit. It should not have been. And so we're taking the city entity off. That is the first chief appraiser motions that require no hearing. The reason they require no hearing is because the tax obligation is going down or less. So it's not increasing the tax liability. The next ones are chief appraiser motions that require a hearing. And I will read those into the record. The very first one is Coconut Bay Estates, Unit 1, lots 9 and 10, which is 5177 Loop 1781. The account number in question is 15576. The error is an error of ownership of a property for tax years 2017 through 2020. A special warranty deed was filed on 4/13/7, granting property to James Robert Harrington Jr. and wife, Mary Catherine Harrington, with a life estate for Marion Reed Burt Harrington. Marion Harrington died in 2007, but the appraisal district was not notified of the death. This motion will correct the ownership from Marion Harrington to James Robert and edX Mary Catherine Harrington for the years of 2017 through 2020. This change in ownership will cause the removal of an exemption, and the additional tax will be due for those years. So this is a situation in which there was a over 65 freeze in place for a long time. This person has a son and a wife. This person can have a life estate, but this person died in 2007 and the district was not notified. We were made aware that the subject property owner had died in 2007 when we received a probate for another will that was connected to the son, who then died in 2020, late in 2020. That's the first time we had a clue that the first person had actually died. We're required to change the ownership upon the information because we're in this record. The removal of the exemption of the first person up here causes a tax liability increase for the heirs. The second heir is the son who died and his wife. So the tax obligation for the years, or the change in ownership, is for the years in question from 2017 through 2020. But this will cause an increase in the tax liability because the removal of the exemption has to go into effect for those years because the person in question is deceased.
Right. So what happened between 2007 and 2017?
There was nothing. We were not notified, and we can only go back 5 years.
Okay, that's the question. Okay.
So we're 17 to 20, 21, 20, 20, 19, 18, 17.
I'd like to ask Mike a question. Mike, did the district send appraisal notices to the life tenant from 2017 through 2020?
Yes.
Or rather, okay. And the owners, neither the life tenant's son nor the life tenant's daughter-in-law ever notified the district voluntarily that the life tenant was deceased?
That is correct. Nobody ever
Okay.
notified.
And the life tenant, Mike, as you understand it, is someone who owns property until the death of that person, at which time the title automatically reverts to the remainder interest. And in this instance, the remainder interest were the life tenant's son and daughter-in-law?
That is correct.
So Mike, is it your position that on the death of the life tenant in 2007, that the district should have been notified at that point because the ownership had changed upon her death?
That is correct.
Okay. And all that's really before the ARB today, Mike, is you're asking the ARB to change ownership for the last 5 years to Ms. Mary Harrington. Did I get that right?
It's through 17 through 20. Yeah.
Right. Mhm.
We did, we obviously in 2020, late fall of 2020, we got a probated will or probate from the county clerk's office that indicated the son's death, in which we were clued in, oh, there's an ownership change here. But not only was it from the mother, but it was like the mother to the son and the son to the wife, because they had mutual interest at this level, or what was called the life tenants. And so in 2021, we put it into the daughter-in-law's name, at which point she came in, this is wife before you today.
And Mike, did the district learn about the probate by obtaining the records from the county court? I mean, how was the district notified of the death of Mr. Harrington?
Of the son, Mr. Harrington, we were
Yes.
notified through a county clerk's document.
Okay. And the county clerk sends over probates to the district?
Typically, yes. We collect them, yes.
So you learned about the ownership change only when the probate landed in your office, right?
Correct.
Got it.
So say the county clerk was delinquent and not sending you the record for of the death of the
You have to
first
probate,
person?
you have to, like, nobody from that estate notified the county clerk.
Either the will wasn't probated or probated in a different county.
Well, there's also muniment of title, which doesn't require the state to go through probate. But it's applied in limited cases, right?
Right, but to the best of the district's knowledge, there was no application to probate the life tenant's will as a muniment of title, and it wouldn't have mattered because title passes on her death automatically. There's no requirement for a probate or for a will in order to transfer property from a life tenant to somebody else.
Do we have to vote on this, or are you just giving us the
It's
information?
a chief appraiser's motion to correct for appraisal roll. This was one that required a hearing because it increases the tax liability. This was one that was previously scheduled, and we thought the person would show along with their counsel. We were informed prior to or at the time of the hearing that they were not going to appear.
And if the district could you read into the record Ms. Barnaby's email
Yes.
about their decision not to appear today?
Okay, and so this was sent from Kristen Blanford
Time.
at 12:17 p.m. on Thursday, December 9th. It was to Val Smith with a CC to Corey De Los Santos. It reads Val and Mike, comma, with parentheses, will you pass along to Mike as well, end parentheses. We appreciate your assistance through these issues and value your public service enormously. Please know that we will not attend today's hearing and are using our time to consider other options and solutions. I just wanted you and Mike to know so you didn't spend time waiting on us. Thank you, Kristen Barnaby.
Okay.
So what you have before you is the chief appraiser's motion to correct for the ownership in question with the facts.
For the last 5 years.
17 through 20.
Real quick, that email was from Kristen Barnaby?
Yes, she's the agent
She's the-
attorney.
Okay, the attorney representative. Okay.
She's a private attorney, not the public attorney.
Yeah.
Okay.
Okay. Moving forward, next, at the end of all the chief appraiser's motions, right, isn't that where they make a motion?
Yes, and then I had talked to Jim. I don't know if you want to speak to the orders on the motion, Jim, or what we'll do as far as Ms. Harrington's.
Well, the board has, I don't know if the board has a draft motion, but a draft order, but it's in two parts. The first part on the top of the page references what the matter being considered is. And in that instance, I think there's a check mark for ownership. And then the second part on the same page reflects the action by the ARB. And the fifth box down in the second part has to do with ownership changes. So if the ARB determines that the ownership would change as the district has requested, then the box would be checked. And then there's a blank that says the ownership has changed from blank to blank. So the action would be that the ownership would be changed from, I think her name is, I forgot her first name. The life tenant's name, I think, is Marion or Miriam, maybe. We'll need to put that in the record, Mike, the name of the life tenant. And then our recommendation is that it be changed from that person's name to Mary Harrington, who is the daughter-in-law of the life tenant. And since she inherited from Mr. Harrington, the life tenant's son, we believe that she is now the owner of the subject property. And there's more than one account, I believe. Is that right, Mike?
More than 1 year.
There's more than 1 year, there's only one account.
Okay. Then I think in that instance, our recommendation, the district's recommendation to the ARB is that fifth box from the fifth box in the second section, it says ownership be checked. And then the first blank would be the name of the deceased life tenant. And the second blank would be the name of Mary Harrington. Mike or Val can give you the name of the deceased life tenant.
Should a motion be made for each year, or typically what the ARB does with the chief appraiser motions is they just say one motion for all of the, one motion here for all of the chief appraiser motions.
Right. Yeah, I agree with Val. They can all be consolidated into one hearing, one motion and one order.
Even with this Harrington. Okay.
That's up to you guys.
Yeah. Yes, and I'll have you sign these after.
Yeah. So
Yeah.
we put the name.
Yeah, I'll get that.
Okay, moving on, the next chief appraiser's motion to correct for appraisal roll is for 217 Marion. This is property ID 66562. It is clerical error that affects property's owner's liability for the 2021 year. Property ID 66562 and 31403 were merged. This manual freeze increase for the Aransas County Road and Flood entity was not entered in error. In 2021, the freeze ceiling for the Aransas County Road and Flood will be corrected from $364.30 to $398.66, which will result in an increase overall of $34.36 for 2021 taxes due. Again, sometimes when you have splits and merges, you have to do manual freeze overrides and you have to include all of the entities. It's probably a keystroke or something like that. So. But it increased the tax liability.
This again was a hearing that was scheduled for today, but there was a no-show.
That is correct.
They were, of course, notified.
Of course. They were both notified.
Yes.
Okay.
Did we hear that as we heard that as a case where they merged two lots together?
You mean,
no?
you mean a different case?
No, I'm curious. I guess it was this case.
Well, it happens more frequently than you would think.
Okay.
So, yeah, no, this would just be, was just a matter of at the end of the year, once the tax rates came in, we calculated the freeze manually for all the entities. We left one off. It just had the original freeze ceiling, so we had to get it added on. Like they've been notified and been notified of the hearing.
Got it.
So that concludes the chief appraiser motions. And then you can move on to another part of the,
And do we need a
Do
motion
we
to
really
accept
Vote on approving those?
yes.
approving those?
Yes.
Okay. So I move that we approve the chief appraiser motions for the 2 hearing cases and the chief appraiser motions for the non-hearing cases.
Second.
All in favor?
Aye.
Done. Then correction of appraisal roll.
With new correction of appraisal roll. You mean joint motions to correct or supplemental records?
I got the supplemental record.
Supplemental records?
Yeah.
Well, in this detail will be some joint motions. Do you want me to go over those first?
Okay,
Okay, let me go over the joint motions. Which is number 8 or VIII.
It's down near the bottom of the
Yes,
list.
joint motions to correct incorrect appraised value. This is, the property in question is 8820,777 for the year of 2021. Incorrect value was 5,000, corrected value was 0. House was sold in 2020, no longer a short-term rental. Basically, this is a short-term rental deletion. Next one is joint motion to correct, account number 14371. The original value in 2021 was 175,670. New value is 153,800. Reason for reduction in appraised value was a correction of the square footage on the new house on the property. Again, this is a joint motion to correct. Third one that you have is account number 65131. This it's for the year of 2021. The property owner has faxed a letter of protest. However, we did not receive it. After reviewing the property owner's evidence, the Aransas County Appraisal District will change the value from 47,250 to 21,260 based on the effective size and also a wetland area or wetland. Again, joint motion to correct. Joint motion to correct appraised value. The next one is 8820,397 year 2021. Removed all improvements on property for 2021 except for SD2 detached storage on PID 8820,397 UDI because all improvements are no longer there. We'll decrease the value from 12,030 to 8,930 for a decrease in assessed value of $3,100. Again, that's a joint motion to correct. There you are.
And that's just a report. You don't need a motion for
Okay.
joint.
all right.
Okay. And then the supplemental records report.
Mhm.
We are going to look at the detail groups, I guess. That is the detail of each one of those groups that you can look at and review. That is a big list.
Like to go home today.
Or you can look at the
You're
December,
gonna order it.
or you can look at the that's the order approving, it's the supplemental leaf. Let me look at the middle one here. Certified roll changes to assess value. This is a summary. That's kind of a easier one to look at. Summary, that's the middle one. Summary of certified roll changes. I'll answer any questions that the board has.
I looked at every page.
You can see if there's an increase or a decrease in valuation.
The red is a decrease
Right.
on the supplemental detail.
A decrease in the assessed value. And then The other detail shows you what the decreases in taxable value would be due to exemptions, late filing of exemptions, and those aren't listed here because there isn't a change to the assessed value, just to the taxable value. But it is a loss of revenue.
Any questions on that summary page?
Yeah, that 25, that 125, at 2.5 million.
That was the Rockport Land Trust was the lion's share of that.
That's one that we ruled on. as I recall.
Yeah, any 25 fees are an ARB ruling.
Yeah, you can add up all mine together and it wouldn't add up to yours.
Does that mean we overachieved?
I'm not gonna have it, I'm just pointing out the math. Not gonna have an opinion about it.
I don't have any questions.
You need a motion to approve.
Yes.
So I move that we approve the certified roll changes to assessed value as shown.
I'll second.
All in favor?
Aye.
Gonna do number 11, new ARB and member and officer information.
What's that?
No, go ahead, do what you're doing right now.
$11.
Yes.
So do you want me to go over this, Charlie, or do you want to do this? I can do this.
Go ahead.
Okay. The new member ARB application is just that I'm a little pretty versed on what's going on. Basically, right now you have a local administrative judge that is taking applications for the appraisal review board members. And I'm going to go ahead and read it. It says, thank you for your interest in becoming an Aransas County Appraisal Review Board member. ARB attaches an application to be filled out and returned below as an outline of the typical commitments of an ARB member. Now, please understand that the board of directors appointed a tax liaison officer. Josie Bonnet is the tax liaison officer. She's in our office, and she handles the application. She receives the application and she has communication with the district administrative judge. So she's the one that handles the applications, the one that hands them out, ones that receives them, one that forwards them on to the district administrative judge. That resolution was passed on the 15th of November, 2021 by the board of directors. Josie Bonnet is our local our taxpayer liaison officer. And it's only for subsection 6.02F, which only deals with appointing ARB members. So she has no other duties as resolved by the board of directors. I'm going to continue reading this on. Term can be up to 2 years, meets twice quarterly for an average of 8 regular meetings per year. Mid-May through September, hears cases 4 days a week. Hearing dockets are 8:30, 10, 1:30, 3 p.m. for a typical 8-hour day. One Saturday morning to hear cases. 1 day of training is required each year. One-time completion of online courses for Open Meetings Act. One-time completion of online courses for Open Information Act. Compensation is for 50 for morning dockets, 50 for afternoon dockets, for a total of $100 for a full day. The average size of the appraisal review board is 5 members. And then you can see the appointment, request for appointment to the appraisal review board. Here's an application. Everybody needs to file. I do know that Scott turned in an application already. Is that correct, Scott?
Yes.
And there's also an application for board ARB positions, like officer positions. I do know that Kathy needs to fill one out.
I already did.
Okay, all right. Moving on from that document, the second one is the appraisal review board officer application PDF. And this is just the officer application, what you'd like to be considered for, your name, address, phone, occupation, email. And then again, this goes returned to Josie Bonnet and it'll be delivered to the administrative judge. The appointment of the taxpayer liaison officer is the last document, which shows you the board resolution, the board of directors resolution. And that's why it's a new law. It's no longer handled through the board of directors. It's handled through the Texas administrative judge. I think it's done with an intentionality of, I think a good intentionality for any kind of influence. And so it's just handled through the Texas administrative judge. I will say that we were early to the game, and the administrative judge was very excited that we had so much enthusiasm to help her, but there's a limited help at this point. It all goes through the taxpayer liaison officer. The main help had to do with the initial setup of this correspondence, and kind of the duties in the application was actually formatted by the administrative judge.
And she, my understanding at least is that she would accept suggestions from the ARB in terms of the board members.
The way I understand it is that if you or anybody in the public has somebody that would like to fill the role of an ARB, all you should say is like, hey, there's a form here you should do, and then submit it to the taxpayer liaison officer, and that should be your only influence. There should not be.
The district, nobody on the district staff is entitled to weigh in or to make any recommendations. The job of the taxpayer liaison officer would simply be to forward applications to Judge Whatley. And my recommendation to this district and others is to not even tell the judge whether a member is a returning member or not. I mean, the judge could glean that from an application, but the district, according to the tax code, is required to be hands off when it comes to making any kind of recommendations or weighing in on appointments, anything of that nature. So the district is not going to say anything about applicants.
Basically, we direct them to the taxpayer liaison officer and just don't even answer any other questions about it.
So any of the suggestions I may have come up with, the approach was, again, here's this application if you want to proceed, but it's a kind of a chicken and egg issue too, because finding people, and to me also, I would rather, well, I'd rather not see an ad in the Rockport Pilot, you know, soliciting people, okay? But be that as it may, that's so any of the suggestions that I've brought forward have been just, you know, here's the form and here's how you proceed.
Just Judge Whiteley take the place of the board of directors.
Yeah, she.
So the board of directors goes away.
No, the board of directors does not go away. They just don't have that duty of appointing ARB members anymore.
Oh,
And so this was informational for you. If you do know of anybody, just say, hey, there's an application, you should go get it.
Yeah.
And then I think that's it. All you should do. That's all we would do. If somebody called in, yeah, here's your application. Let me put you in touch. Here's the taxpayer liaison officer. She would get on the phone and here you can pick it up, you know, here it is.
So we shouldn't talk to people who we think would be and tell them about what this job is.
Jim, do you want to weigh in on that?
Yeah, I didn't quite hear the question.
The question was, so would like myself or anybody else on this board not be able to have conversations with individuals that we feel would be appropriate or would be interested in the job?
I think you can approach people in the community, but the extent of your involvement would be to just tell them, fill out the application and give it to the taxpayer liaison officer. It's possible that the judge would interview applicants. So there might be a conversation between the applicant and the district judge. But as far as approaching members of the community, recruit them, whatever you want to call it, I don't see an issue with that, as long as you just tell them, here's an application, or here's where you can find an application. And you should fill it out and submit it to the TLO, taxpayer liaison officer.
But I guess my real question was, can we then not have a discussion with this person that we feel would be appropriate and tell them about the job?
I think that's entirely appropriate. That person ought to be able to understand what's involved in functioning as an ARB member. So I think giving that person the rundown on what you do, your duties, et cetera, is within the tax code. I don't see any problem there.
All right, thank you.
That's it for that section of the agenda.
Okay, you want to go back to item 4, approval of previous meeting minutes?
That sounds good.
Is that the bottom one, 4?
It is.
Which one are we on? Number 4?
It's at the very bottom
On the
of the
tablet.
tablet.
Oh, I was just looking at our.
Yeah, it's number 4.
Yes.
And it is number 4. on this.
Yeah.
Boy, November 1st was a rough one. A long day.
Yeah.
Yeah.
I should have. No emphasis injected in another letter.
So that's there's only one page.
Yes.
What I remember.
Yeah.
I move that we approve the meeting minutes from November 1st, 2021.
Second.
All in favor?
Aye.
You have no more minutes?
What is it? Letters to be read?
Please letters.
I know, we didn't get this one until the 6th.
Okay.
Item
Just
number
a couple
5.
days ago.
We're doing item number 5, letters to be read.
Okay. So this was received December 6th, 2021. Property ID 14100 and 14101, belonging to Jerry and Nora Sauls. Rockport, it's a 2525D request. Dear Mr. Powers, I am inquiring as to why my tax bill did such a great jump in value and tax amount from last year. We were not able to protest amount at the due time due to COVID virus and sickness. The virus swept through my family, taking the life of my daughter on 9/1/21 and my husband Jerry on 9/22/21. My son and I survived due to the grace of God with lingering effects. I am attempting to pay tax bills and was very surprised at the great difference from last year's amounts. Would be so very grateful for any explanations and help you may provide. I'm 85 and not able to drive to Rockport for assistance in solving this. Thank you very much for your attention to this matter. Please call me at a phone number or email, They live in Pearland, Texas. Signed Nora Sauls.
Has anybody answered the letter?
No, it was directed to the, well, it does say appraisal district at the top, but then it says, Dear Mr. Powers. So we just waited, like I said, it came in on December 6th. We have the meeting today, so
So how would they know to send it to Powers
I
or
think
address it to Powers?
probably talk to someone at our office, maybe. It just has a little line there that says Texas Tax Code 2525D.
Yeah.
So my thought would be that the ARB would want to send them the motion to correct that they could fill out and return, if that's what they're wanting to do.
I'm not asking for a hearing.
No?
No, they're just asking for an explanation, what it sounds like.
Well, no, actually, I think what they did was they called in and somebody said that at this point, it's too late to protest it, but you do have the option of doing it, filing for a 2525.
Right.
And that's what they're doing here, is asking for a 25.
And this is the only letter we've gotten from
Yeah,
them?
but doesn't it just say at the
Yes.
bottom, I would like an explanation?
Yeah, they're not really
Just
asking.
asking, all they're asking for is an explanation of why their taxes are higher.
Do you think y'all might want to run that by Mr. Hinkle and ask for his advice on that?
I would say that because we don't really give advice.
Okay. And offhand, I would, I'm just talking out loud here. I'm not suggesting anything, but if I were to respond to this, it would be, your appraised value went from this to this, and the tax rate was that. The old number was this, and the new number was that, and just explain where the old tax number came from and the new tax number. But I don't know if that's appropriate or not.
Yeah, the clue to me is she doesn't know the Texas tax code 2525.
Yeah, exactly.
So we probably said, hey, the only thing you have left to you is here, because it's not even a late protest for good cause. Once the roll is certified, you don't even have that available to you. So all you have is 2525D at this point.
And she may not even know what that is.
She doesn't know what that is. So she was told that that's
The only option, yeah.
So the suggestion is forwarded to the attorney.
She's not asking for she's not asking for a hearing on that. She's just asking for an explanation of why her taxes increased.
Yeah.
Run that test.
Excuse me. Okay.
So, yeah.
So I move that on property ID 14100 and 14101 belonging to Nora Sauls, that we contact Skip Hinkle and get advice from him on how to proceed with this letter.
Who's we?
The board.
Yeah,
Charlie's looking like, who's we? He's looking at his watch.
No,
He's
I said-
imagining his watch.
I'll second that.
You got about an hour. Well, hang on, I mean, is this something you guys? No, okay.
No,
never
it's
mind.
just gonna skip and then I'll
Yeah,
come back and
right.
we'll do something with it.
What
And the
we'll
suggestion,
do is Val will send it to Skip with whatever background materials necessary. And then he'll render opinion.
There is no other data, just that letter.
yeah, and since it's really not our in our purview to assist or suggest or whatever, that
Right.
when it goes to Skip, maybe it can be stated, can you please handle this?
Respond to it and then Dell can respond to it. Leave.
At this point, I want to officially recognize Mr. Powers for his very long years of service. And I want to say thank you for putting up with us and citizens and your fellow members for all of the difficult cases that you're. Well, that's why I started with us, the district representatives and the citizens and your fellow members for your long years of service. So thank you, Mr. Powers.
Thank you, Mike.
And he will be missed. He's been a great president and thank you so much.
That's right. Robert is as well has indicated that he's coming on. And thank you for serving as well, Robert. Appreciate that. Bill's still deciding, I think.
I haven't made a decision.
Yeah.
Yes, you're staying.
Well, that's all up to Cindy, I think, so, or their mutual decision.
Well,
Yeah. it was- And Scott has already indicated that he's applied. And you turned in your application as well, Kathy, so. I have had communications with the district administrative judge that, hey, we want to add some new auxiliary members. But that's totally up to her. I mean, she's the one that appoints at this point. So. We are there.
we're there.
So do I need to say anything more about
I think I seconded it.
second? Okay.
Oh, yeah, we didn't better. Hi, all in favor?
Aye.
Sorry about that.
And
So-
to be clear, whatever Skip answers, we can formulate a letter and I don't know who would sign it, but I guess if it's before the end of the year, I would send it to you for your signature and we could
Sure.
send it on out because hopefully the board won't have to meet until, sometime in the first quarter later rather than sooner.
Right.
Yeah, I think it has to be after the education. Remember, we did that last year.
For the hearings, but Jim clarified with us that we can have a regular business meeting without the education.
Right.
Are you still there, Jim?
Yes, the only requirement with regard to going to school and attending meetings is attending a hearing. You have to finish the course before you can participate in a hearing. But the code does not prohibit meetings in which the board will make a decision on a protest or a 25-25 motion. So if it's a regular business meeting, then there's no requirement that the course be completed.
So because the training hasn't been made available to us until. Right?
Yes.
And so we had that issue last year that new people, which was Scott
And Bill
and
went
Bill,
through it.
yeah. We had a meeting, our first scheduled quarterly meeting came before we were able to complete the training.
Right.
Yeah, the board, the way I understand it, Jim, whoever's assembled at the, on the board they can hear,
Can't participate.
they can hear the supplemental report. They can just hear it, right? I mean, you just listen.
Well, put another way, an ARB member who hasn't completed the course may participate in uncontested matters.
So.
And I would extend that to, well, anything like a hearing where they don't show up, then you've got to go to school for that. But accepting the appraisal roll, accepting supplements, my opinion is that this is my opinion to the appraisal district, not to the ARB, because I don't represent y'all. But the district's position would be that to accept supplementations does not require course completion.
So I'm confused here. So new members, and there will be 2 or 3, can participate in our first quarterly meeting if they haven't had the training because the training's not been available.
No, they can participate in the first quarterly meeting as long as there are no hearings at the first quarterly meeting. There might be other things like accepting certifications, whatever housekeeping the ARB might need to do, things of that nature. You're not permitted to do anything else. For example, attend hearings, rule on hearings until you've completed the course. The only exception to that is when the courses are over, and that's late spring, I think, and there's a vacancy that's filled, then the new ARB member is entitled to participate in hearings, cast votes in hearings, because the courses are finished, they're over with. But if you're in January and you haven't attended the course, of course, there's no course offerings at that point. You shouldn't be having ARB hearings.
Well, the only question I have about that is, should we end up with a situation where we have 3 new board members? That would leave
Not a quorum.
2 of us without a quorum.
That's right. You have to wait. You have to wait until the your course has been completed.
So we really can't conduct any business or hearings until possibly the second quarter after the training has been made available.
That's probably true unless the board is going to meet for matters that aren't related to hearings. I don't know what those matters would be, but you're right. You cannot participate in ARB hearings until you finish the course. And if you don't have a quorum, well, you've also got to take the refresher course if you're a returning member. And so in any event, you need to take the courses in order to have hearings. So you're going to have to push the hearing schedule, back to, like you say, the second quarter, maybe. But and that all depends on what the controller's deciding on scheduling.
Right, if somebody gives us a 25D motion right now, they probably won't get their day at a hearing until May.
Unless they, unless they, waive notice and want to squeeze it in before the end of the year. But the board members whose terms are up on December 31st cannot come back. So unless everybody agrees to have a hearing before the end of the year, you've got to wait until the courses are being offered.
Okay.
Is this, I mean, just as an aside, is this any different than what you guys have had to deal with in the years? Yeah. It's the same.
This is the way it's been done for a few years.
Yeah, no, I understand.
Yeah.
Last year it was, I believe, in April. Was it in April or-
The
We
training
did it
itself,
online, but
yes, I think so. It was
April.
it was available around mid-March.
was it? I know, I did it like right away.
I don't
and I think
remember.
it was.
Yeah,
Yeah.
it's silly that they.
If it's
don't have it
video, it's
already.
easy.
Yeah, they
If
still
it's
have it.
video, it's easy. I mean, just-
Yeah, you do it online, it's not a problem. The problem is when they make it available. It's not just sitting there waiting for us. We have to be told when it's gonna be online or presentable.
Oh, it's not the same course over and over. and
No,
over again?
things change.
Like you
Yeah.
couldn't take it now.
Different things change, and so we have to be made aware of those.
I just assumed they were canned meetings that have been going on for years and years. and
Every year
years.
it's different.
Really?
Some of the things are the same, but then if there's been a change made to our responsibilities or how we handle something based on what God knows who did, it's new.
Property tax law change.
The legislature might have changed the law during a legislative session that affects ARB members. It's also possible that there's case law that interprets something in the tax code or some other law that may affect ARB members. So that's right. Every year there's a different course. I mean, they kind of plow the same ground, if you're talking about methodology, things like that. But things do change over time because the legislature enacts laws and courts interpret them.
And they're the ones that make it available.
Yes, the
The
comptroller's
legislature tells
office,
you when you can have it.
The comptroller does.
Texas comptroller.
I'll make a motion that we adjourn.
Second.
Thank you, Jim.
Well, thank y'all.
Bye.
Thank you, Jim. I'll miss you.
Well, miss you too. Hopefully our paths will cross in Aransas County. So
Absolutely will.
we'll see y'all.